Now, this week, the corporate regulator ASIC had a big win against one of the big four banks, Westpac, about advice it was giving to its customers about swapping into in-house superannuation. This was an appeal against a previous decision by the courts that said that the banks weren't in any problem with their best interest duty to their customers. ASIC's proved that they were. So joining us live now is Deputy Commissioner Daniel Crennan. Daniel, thank you for your time. Why is this such a significant decision?
It's a significant decision partly because it relates to superannuation, which is one of the most important assets in most Australian lives. It is a significant decision because a bench of 3 judges have delivered individual but decisions that are in concert with each other, analysing the conduct of the bank, that is the telephone calls in question, firstly determine whether or not it was general advice or personal advice within the meaning of the Act. That is extremely important, that distinction, because if it is personal advice, either on a subjective or objective basis, and they found that objectively it was personal advice, then that triggers a number of obligations throughout the Act which are in themselves very important. And in this case, it was to act in the best interests of the clients or customers. There's a number of reasons it's significant. The bench is an appellate court of the full court, including the Chief Justice, and we're very pleased with the result.
One of the things that struck me with this case was these phone calls were made between 2011 and 2015. We've only had this successful appeal now. That's an awfully long time for the banks to be held to account.
Well, in some circumstances, litigation does take some time. There are steps taken within the agency and certainly within the court to endeavour for expedited investigations and hearings, and with the court, the agency is hoping that delays will shorten and decisions like this will not take as long as this one may have.
One very senior lawyer has been quoted as saying if general advice isn't dead, then it's at least on life support. Do you think that's true?
Well, the person's entitled to their opinion. No, I disagree with that. The agency's view is that organisations are perfectly able to give general advice or helpful general advice, but they have to be cognisant of what might be conduct which gives rise to an objective analysis of that conduct such that it is taken to be personal advice. And as I said earlier, that triggers a number of obligations which otherwise wouldn't arise. Those that design the frameworks, as they're sometimes called, such as the one in this case, which is called the QM framework, have to be careful that the person who's listening to the call, that the caller's statements, is not put in a position where, as a reasonable person, they would assume that the provider of the information or the maker of the statements is taking into account their objects, their financial situation or needs. Any one of those matters would give rise potentially of what might be described as general advice, but actually, from a legislative point of view, is personal advice.
Should the other big 4 banks be worried?
It depends upon their conduct in the past. Of course, this judgment, which is potentially still subject to appeal, but as it stands now, is a very helpful judgment for those that design such frameworks to avoid, as best they can, the possibility that they are in fact providing or can be taken to be providing personal advice, notwithstanding they take steps such as describing it within the call as general advice and so forth. So there's a lot to be learnt from the judgment, and it pays for reading. It's long, it's 149 pages long, but it's very worthwhile. Each judge has given a very comprehensive analysis of how the legislation operates in the context of these particular calls.
Now, ASIC's been told in no uncertain terms the new mandate has to be why not litigate? Previously, the answer had been because you tend to lose a lot. Do you think this is the turning point for ASIC?
Well, the phrase why not litigate comes from us, in fact, and it comes from a comprehensive review that was undertaken and submissions that were made to the Royal Commission last year. It does represent a shift towards a more punitive orientated, in other words, litigation orientated agency, which is very much benefited, obviously, from recent legislative reform attaching attaching civil penalties that could be pursued in circumstances where contraventions are proven. For example, in this case, part of this case is the bank failed to observe its obligations under 912A to act efficiently, honestly and fairly. Now, when that conduct took place, there were no civil penalty consequences. There were no consequences of breaching that provision, and there's a similar provision in the Credit Act. Now, as of the 13th of March, there are very significant civil penalties. So as the legislative reform has evolved, as ASIC has evolved, and as the Royal Commission took place and much misconduct was brought to light to the public through the media and otherwise, the whole framework in which we are operating has changed. So I'm not sure if it's a turning point necessarily. Litigation is what it is. You get your decisions and you decide whether or not to appeal until you've exhausted your avenues of appeal. But it is a representation of ASIC's at least willingness to continue to push its view as to what the law means and how it applies to particular sets of conduct and seek judgments from the court.
When it comes to what came out of the Banking Royal Commission, the number one thing I've heard from just members of the public is, why didn't we see any criminal charges come out? Is there a good explanation you can give them for why we haven't seen any criminal charges yet? Well, there have been criminal charges laid recently in relation to anti-hawking legislation. That wasn't directly... But that was prior to the Banking Royal Commission that was underway, and that wasn't from evidence from the Banking Royal Commission. That's correct, but it related to matters that were raised by the Royal Commission as to ASIC's response to hawking. Whether or not there are criminal charges being laid directly relating to a case study remains to be seen. As an agency, in cooperation with the Commonwealth Prosecutor, a number of decisions have to be made as to whether or not the conduct amounts to criminal conduct, and whether or not a civil penalty process should be undertaken, and whether or not there's sufficient evidence such that the resources of the agency and the CDPP ought be applied to a case or not. So these are prosecutorial discretion decisions that we make all the time, and whether or not criminal cases arise from the Royal Commission or cases that relate to the Royal Commission, we'll have to await the investigations and that process I've just described. Are we likely to see any criminal charges from that process you've just described before the end of the year? I can't really comment with that degree of detail, I must say. So what confidence can you give Australian consumers that ASIC is being the tough cop on the beat? Well, I've heard that expression for a while. If you look at what's happened recently, we've issued a number of cases about a number of different types of misconduct against very large organisations, including the banks, and also organisations that are not banks but subject to our jurisdiction, and they cover a number of different types of misconduct, as I said, that were ventilated in the Royal Commission and either arose directly or indirectly from the Royal Commission. Now, that's not to say necessarily that that's a manifestation of a huge seismic change, but the recent history of issuing proceedings that relate to the Royal Commission should give the public some comfort that we're investigating those matters that are sometimes quite complicated, but with the cooperation of the regulated populations and with our endeavours and better funding and so forth, I think the public should be comforted that we are responding not just to the Royal Commission but other misconduct that the Royal Commission may have mentioned that we may have been already aware of. Daniel Crennan, thank you very much for your time. Thank you, Annalise.